welcome to the Legal Issues in the Age of Climate Adaptation webinar. My name is Bruce Hyde, and I am a land use educator here with the UConn Center for Land Use Education and Research. This is the third in our 2017 webinar series. Hold on for a second, we got to switch seats here. We didn't plan this very well. This is the third in our presentation. The first two, getting started with your new MS4 permit and road salt use in Connecticut, have already been held, and if you would like to see them, they can be accessed at our website, clear.uconn.edu. Today we're going to talk about climate adaptation, legal questions and answers, and more questions, and we're very serious about wanting more questions. We want you to get in as many questions as you possibly can, and we will do our best to answer them all. We structure this so that the presentations are fairly short and have a lot of time for questions. The next webinar is May 24th, and it is Meet the New and Improved CT Eco. Will be presented by award-winning Emily Wilson, who is very, very knowledgeable in this stuff, and in fact, she could be described as being Ms. Connecticut Eco. A little bit about the Center for Land Use Education and Research. We focus on three areas: land use and climate resilience, water and geospatial technology, and our mission is to provide information, education, and assistance to land use decision makers in supporting balancing growth and natural resource protection. The presentation today is as a result of a webinar we held in November of 2015. I know that was a while ago, but we had a lot of work to do in between. The legal issues of climate adaptation, and we received, in response to a request for people to ask questions, 56 questions, which we subsequently have cataloged and turned over to the Marine Affairs Institute at Roger Williams Law School and the Rhode Island Sea Grant Legal Program, where they took a bunch of the questions and put together fact sheets that address the questions. So those fact sheets include takings and coastal management, property and permitting boundaries at the shoreline, government tort liability for disclosure of flood hazard information, I think that one's my favorite, and flood and erosion control structures. So today's presenters, and I'd like to thank both of them because we are very lucky to have them, is Reed Porter, who is a senior staff attorney at the Marine Affairs Institute and Rhode Island Sea Grant Legal Program at Roger Williams University Law School. And providing unbelievable support and help is Audrey Elzerman, the Rhode Island Sea Grant Law Fellow, and Audrey was a huge contributor to this project. In addition, today's presenters is Marjorie Shansky, who is a solo practitioner in New Haven, where she practices in the area of land use and real estate law and specializes in environmental issues. Marjorie was an original presenter in the November Climate Adaptation Academy legal presentation and was also a panelist there. And many of you know Marjorie, but many of you may not know that she's an accomplished flautist who plays for the New Haven Symphony. So if you have any environmental real estate issues that you need to have addressed, or you just need somebody to play the flute in your orchestra, you can get in touch with Marjorie. She'll take care of you. So the questions that we got from the original workshop, as well as answers and the fact sheets, are all available at the AdaptCT website, climate.uconn.edu. And with that, I will turn it over to Reed Porter to talk about the fact sheets.
Okay, thanks, Bruce. Hi, everybody. Hopefully you can all hear and know how to ask questions. What I'm going to do is I'm going to give an overview of who we are and what we've done, and then we'll have questions after that. So About the Marine Affairs Institute, we are based at Roger Williams University School of Law, but we're a partnership with RWU as well as Rhode Island Sea Grant and the University of Rhode Island. The partnership with the Rhode Island Sea Grant program comes through our hosting of the Rhode Island Sea Grant Legal Program, and I'm a member of that team. We are an academic and research institute, so we do not advocate or litigate. So we're here really as a legal research resource for folks. Our mission is to educate the next generation of marine law and policy professionals, including Audrey Ellsman, who's here with us today. We also serve as a legal and policy resource and do convenings to address issues of import in marine law and policy. The Rhode Island Sea Grant Law Fellow Program is the tool that we use to help with this project. We provide low-cost legal research and analysis for outside organizations under my guidance, and our work can be with government, it can be with nonprofits or industry, and covers both local, regional, and national issues. So we're really happy to be able to help folks in Connecticut with projects like this. This project, as Bruce went over, came out of those questions from the legal issues workshop, and Audrey was really the lead on answering these questions for us. I'm just here as the talking head, so we're really pleased that she was able to contribute. And our focus was on answering as many of those as we could, but we did end up grouping them into 4 categories, and we'll go through those just quickly here. The first one was property and permitting boundaries at the shoreline, and there was a bunch of questions here about where does deep permitting authority stop and start, and how does that relate to where property boundaries are between public waters or public lands into the marine environment and private land. So as a quick review, the public trust lands start at the mean high water line. So anything above mean high water can be private property, but that's a different line from the permit line, which is where deep permitting authority starts. That's the coastal jurisdiction line, or the CJL, and that's based on elevation. So those may or may not be in the same location on the beach, and they may or may not change in the same change over time in the same way. So coastal dynamics can change how the beach works and looks over time, and those changes can affect those property and permitting boundaries. Property lines can change suddenly. In the case of a sudden change to the shoreline, which is known as avulsion, there aren't changes to property boundaries. However, erosion or accretion, which are more gradual changes, do result in changes to the property boundaries. So those lines can move seaward or landward based on those forces. Deep permitting doesn't have that same sudden versus gradual distinction. So when the elevation changes, so will the CJL. So a storm like Superstorm Sandy can sort of wreak havoc with where each of those boundaries is located. It is worth noting here that DEEP has issued a general permit for coastal storm response that authorizes certain activities to prepare for and recover from storms. So in the case of something like an avulsive event, landowners are authorized to get a quick response to restore their property as it was before the storm. The second fact sheet that we looked at was takings and coastal management, and there's some basic questions here about how to change takings, as well as some more specific ones. So we wanted to give a sort of a broad overview of takings law through this one. As a review, there are takings under the state and the federal constitutions. They cannot be changed by statute because they are a constitutional matter. And takings include regulatory takings, and that's a function of inverse condemnation claims, is what they're called, when regulations limit land uses that are equivalent to if the government actually took ownership of the property. Now there's 2 categories of that, and one is a per se or a lucus taking, some know it by, In Connecticut, it's also called a practical confiscation, where a government action creates a loss of all property value. Lesser losses of property value can also result in a taking in some cases, and that there's a three-part balancing test that's very fact-specific that you look at to see if a taking has occurred. There was a question about takings by inaction, and there are some cases where courts in Connecticut have held that a taking has occurred when the government failed to do something. Usually it's where a government does something that creates a limitation. But where, quote, the inaction claim is based upon a provision that is mandatory, and so long as it has been sufficiently relied upon by the property owner, a taking can occur. That is going to be a pretty rare situation, though. One other issue to think about in terms of taking is some recent cases from the U.S. Supreme Court looking at Army Corps liability for takings based on flooding that's occurred in the Mississippi River outlet. One case was after hurricanes, including Katrina and Rita, as well as some others that flooded in New Orleans in part as a result of the Army Corps' failure to maintain the Mr. Go, the Mississippi River Gulf Outlet Canal, which was supposed to allow cargo ships to make it to New Orleans. The little graphic there from NOLA shows the widening of that and the loss of wetlands over time, and the widening allowed storm surge to build up and caused increased flooding in New Orleans, and the court did find that was a taking. There was a second case involving water diversions that deviated from the Army Corps water diversion manual, and that was also held to be a taking because of damage to state forests. So the lesson here is if you build flood control infrastructure, these cases suggest that you should be careful about thinking through your liability as a governmental entity and make sure that you maintain that, or you could be on the hook if damage results. The third fact sheet is about government tort liability. So takings is one type of liability. There's also a variety of other ways that governments could be on the hook for liability in tort law, or if somebody gets hurt, somebody has to pay, is basically the principle of torts. And the questions here are about if a government gives out information in, for example, a coastal management plan about potential flood risks, is that a source of potential liability for the town? Most of these cases would come through the theory of negligence, which requires plaintiffs to show 4 elements in order to prevail. But we don't get too far into those elements because, in fact, sovereign immunity and statutory immunities both protect governments from tort lawsuits. So the state and its employees are both protected by sovereign immunity, except where the state has provided specific consent. And the second piece of this is that municipalities and their employees and agents, such as members of boards, are also immune from tort lawsuits, except where they're statutorily made liable. There are a couple of cases where statutes do make them liable. One is for negligent performance of ministerial acts. And a ministerial act is one that does not include the use of judgment or discretion. So if by law you're required to give out a license or a permit upon application and you fail to do so, that's a ministerial act. A governmental act is sort of the other side of that coin, where a judgment or discretion would be required. And in most cases, there is immunity for those governmental acts. There are a few exceptions to that governmental act immunity, and we'll look at those a little bit. But there are also specific immunities for municipalities and their employees that do apply in the flood and erosion control context. They're listed here, and I'm not going to go through them all, but one I will note is the 4th bullet down, which is issuance or denial of a permit or other approval that is discretionary. So that would include something like a coastal site plan review or a DEP permit if that was a town action, which it's not. It's retracted. So issuance of a coastal site plan review is not something that's likely to give liability under a tort law. So just a quick rundown. That was a lot of material, I know. So government tort liability and coastal management. Deep is going to be protected by sovereign immunity. Municipalities are going to be immune from suits arising from permitting actions. And municipalities are also unlikely to face tort liability for providing or failing to provide information on flood hazards that they're not required to give out by law. So that last point is because they are governmental acts. These are discretionary actions by the municipality, and the municipality does not owe a duty to a particular landowner to provide or not to provide information on flood risk associated with that property. It's a duty, if anything, owed to the public as a whole. So even if a town is not immune, they'd be very unlikely to lose a case like that. Our fourth and final fact sheet is on flood and erosion control structures. And there's a bunch of questions around this. And a lot of these are hypothetical questions about if different property owners take different actions, what liabilities are around, or what are the permitting requirements for flood and erosion control structures. And we tried to answer in the fact sheet as many of those as we can. A quick review of shoreline flood and erosion control structure permitting. The federal Clean Water Act and Rivers and Harbors Act authorize and require the Army Corps of Engineers to issue permits to place any dredge or fill material in waters seaward of the high tide line. So there's the federal permitting that's carried out through the Army Corps. There's also state permitting through deep permits, which are also required under state law to before placing any dredge or fill material seaward of the CJL. And then finally, there's municipal authority, and that's through the coastal site plan review and approval by town zoning commissions for shoreline flood and erosion control structures. And that's within the coastal boundary. The coastal boundary is the 100-year floodplain or 1,000 feet, whichever is greater. So that goes well beyond the beach where the other two start. The definitions of shoreline flood and erosion control structures under this are pretty important if you're thinking about living shorelines in particular, because they include structures the purpose or effect of which is to control flooding or erosion. And that includes a number of specific types of flood and erosion control structures, breakwaters, groins, etc. However, living shorelines projects and projects the primary purpose of which is to provide habitat or other environmental services are not considered shoreline flood and erosion control structures subject to coastal site plan approval. That's an area where the state and municipalities may have different viewpoints on what is and what isn't a living shorelines project, and that's an area where perhaps some guidance would be helpful in clarifying things over time. In any case, if a structure is a flood and erosion control structure, such as a seawall, it is required to be approved by the town if it is necessary and unavoidable to protect certain structures or facilities, including inhabited structures, so residences, infrastructure such as roads, or a couple of other things like cemeteries, if there is no less feasible, less damaging alternative available. Last slide is on liability. Governments, again, to be liable and tort for these permitting actions that they're taking. They are also unlikely to be subject to takings claims. But there is an interesting perspective in that landowners who put these types of structures in their property could potentially be opened up to liability to their neighbors if their structures cause damage in neighboring areas due to erosion or flooding. We looked at whether those liabilities might exist under 4 different types of law. One is the right to a view, which doesn't apply. There's also a duty to provide lateral support. We also basically found that doesn't apply. But trespassing and creating a private nuisance could both potentially result in liability to neighboring landowners. However, there aren't any cases in Connecticut that we were able to find to date on this, but there have been a few in Washington and Massachusetts. These are very fact-specific types of questions, so it's something to think about for the future, but we didn't find anything so far today. So the last point is on these fact sheets, all of these issues that we've been talking about so far today are very interrelated. And there's more detail in the fact sheets than I was just able to give there. So I would suggest looking at the details on there for specific questions that you have. They provide general principles that we hope you can use to reason through things and specific fact patterns that you might have in mind to organize your thinking, but try to use them together. Keep in mind when you're doing that, they don't cover all the topics that are out there. They don't cover all the sources of potential liability. So there may be other things out there that we didn't cover. They're not totally comprehensive. So thank you. That's all I've got.
Why don't you stay right where you are, and we'll just take a few questions to answer them, and then we're going to save the rest of the questions that we have till the end. First question we have is, are municipalities liable for a lack of maintenance on green infrastructure enhancement for flood control, which is shown in the takings fact sheet? Thinking of living shorelines on this one, or could the immunities on fact sheet 3 be applied to nature-based solutions?
Yeah, that's a great question. Thanks. I think it would be something that you'd want to look at a living shoreline project similarly to any other kind of infrastructure in terms of liability. So permitting for a living shoreline project would be under the same immunities as any other kind of project. And in terms of takings, again, the same takings principles would also apply.
All right, the next question we have is, are the boundaries viewed the same along a lake shoreline as they are along an ocean shoreline?
I would guess that the answer to that would depend on the particularities of the situation. The submerged lands in a lake may or may not be public trust lands, depending on who owns those submerged lands. So it would be hard to make any claim about that, as a general matter.
Okay, and then the last question we're going to take before we move on to Marjorie Shansky. If a hard armoring project is not permitted and a, quote, soft armoring, end quote, alternative, such as a marsh restoration project, fails to provide necessary or stated protection and buffering of a shoreline property, can that be considered a taking? Can performance not equivalent to hard armoring cause a liability, be a cause for a liability suit if hard armoring was denied in favor of the soft alternative?
In general, it's hard to say, specific takings claims are very case specific, very fact specific. So it's hard to make general statements on this. However, what I will say is that under Connecticut law, a hard armoring project will be approved if it's necessary and unavoidable. In that sense, there's taking protection because a house or other full taking of the property is not going to be dependent on the performance of the living shoreline project. Where there are lesser projects that are engineered out and are approved, I have trouble seeing that a taking would be likely in that case, but again, it would be very fact specific. I think it's more likely that there would be a case against the engineer than against the municipality or the state.
All right, that's the last one we're going to take right now. We're going to save the rest of them for later on, but please keep submitting your questions throughout the presentation. I'm going to now turn it over to Marjorie Shansky, but before I do, I'm going to correct an oversight, and that is to mention Juliana Barrett, who is the co-director of the Climate Adaptation Academy and also came up with the idea for it. So she had the original idea and works very hard on assisting municipalities with climate adaptation and other issues. So Marjorie, I think it's ready to turn it over to you. Hit that button to move on.
Thank you. Thank you, Bruce. I am Marjorie Shansky. I'm a lawyer in private practice and am making the disclaimer that I am not providing legal advice today. This is a subject in which I have a deep interest. It's part of my practice and part of my teaching, but you're not my clients. So I guess I'm coming from a practical perspective to talk about, after the chilling effect of the fact sheets, which may have had a stultifying effect on your willingness or belief in your ability to go forward and plan and regulate to the rising sea, to suggest that you have those rights, and that I think the keys are, and this will be echoed in my last image, to keep doing the science, keep accumulating the information, keep planning, keep mapping, keep adopting in your documents, in your plan of conservation and development, in whatever ancillary documents or standalone documents that you're doing, like coastal hazard mitigation plans, and the various and wonderful planning that is going on all across the state, not least of which is on the shoreline, and keep incorporating those goals and strategies into your zoning regulations and subdivision regulations, so that there's a trail, so that if and when challenges do occur, there's a solid evidentiary background that supports the agenda of the municipality. Keep learning, keep educating. I think education is going to be the main key, or among the main keys, because the paradigm has to shift. There is no status quo from nature's perspective, so under what audacity do we think that we can keep moving in the same ways that we've been moving? And then keep coordinating with the state to make sure that the legislation is in place that enables the municipality to go in all the directions that I would suggest you are able to go. So these are options. And once you've accumulated the underlying, of course, armoring is out there, and you'll see in the ensuing images, and I'm hoping to keep my comments short, which would be uncharacteristic for me, frankly. The idea of the armoring butts right up against the very interesting issue of the public trust, because if the sea is rising, or because the sea is rising, public trust land is moving landward. And if we are abruptly stopping that migration, there is a tension, at least dating back to 1892 in the Illinois Central case, talking about the public trust and the inability of the municipality to abdicate its control of it. So if we're saying that the shore stops here, then we have sort of given away the right to the future holdings that the public trust would have given. Now, this may seem entirely theoretical, and but I would submit that it is important to think about, sort of in contextualizing and looking at the total picture of what we're being faced with on sea level rise and regulating to it. And I digress to say that these magnificent fact sheets, which are obviously the product of a lot of hard work, offer a very extensive reading list in the endnotes, and that you shouldn't just stop by reading the fact sheet, in my opinion. Continue and read the endnotes, because that will give you a lot of the particularized information, especially in the Connecticut context. So, living shorelines among the defense, accommodation, and retreat mechanisms. Overlay zones are being implemented in places that are identifying, having done the planning and mapping, conservation areas, adaptation areas, and retreat areas. So maybe you are moving back your setbacks from the water. These are all things that ought to be considered, but they have to be the product of science and mapping. Transfer or purchase of development rights. Certainly if it doesn't overcome a takings claim, it certainly mitigates it. It depends how you look at the Penn Central case, in which there was a transfer of development right in addition to the Supreme Court's finding that there was, let us say, adequate economic benefit being derived from Grand Central Terminal. And then there are rolling easements, which I find to be a fascinating topic and that interfaces with my interest in the public trust doctrine. To the extent that this water is encroaching on land and the public trust land is expanding, the issue becomes, do we recognize that the easement to the public continues landward with the rising water? California actually has a very progressive regulation that acknowledges that the element of the property that may be evaluated, we call it the denominator, what the whole property is, can be divided into temporal sections, not just property sections, so that they permit further setbacks, elevation, and based on the 100-year economic value of the house, which would pretty much take into context take into consideration the sort of window from a sea level rise perspective. So this Professor Titus has written extensively on the rolling easement, and I commend him to your attention. And you know, the Lucas case was mentioned by Reed. That is the case that established the principle of the categorical taking when all economic use of the property had been alleged to have been taken. In this image, there's that sort of modern house in the middle. Those two properties on the sides are the two Lucas properties on each side of that house. And it's sort of interesting, given the development on that coast, notwithstanding the adoption of a new law that restricted construction. Goodness sake, everybody's already constructed. What do you mean I can't build my houses? But there's an interesting question as to whether the public trust doctrine, accretion, and erosion are background principles of state law, which was part of what Lucas said. Yes, there's a categorical taking unless there's a background principle of state law under which the owner would have been precluded from building anyway, so that his expectation, his reasonable investment-backed expectations, to go over to the Penn Central test, would have been diminished and negated really by the background principles of law. So there's a question. These are not questions that are necessarily answered, but they loom for further attention. Similarly, is prevention of waste a background principle in Lucas? If you don't permit armoring and you have the sea encroaching and ultimately overwhelming the property, and now that's become state land, is the retention of that house in that site committing a waste to the state's public trust land because you've left a house now in the foreshore or where people are permitted to travel as members of the public? They're fascinating questions. You may think of them as esoteric questions, but I think they're questions that loom as we look at how to deal with the rising sea. Now, the other side of the story is that this is extremely valuable land, although there is across the state of Connecticut some very low impact housing or situations in which it's not the toniest neighborhood in town. But we also know there are towns in which there's heavy reliance in the grand list on the value of those communities. And we know that towns are risk averse and nobody likes change. So one of the places that this is being acted out is on the immediately adjacent to the water properties that are in many, many cases non-conforming as to lot size, and they are beleaguered in many, many towns by needing to seek variances in order to elevate to get above base flood elevation, or hopefully with some modicum of freeboard because it just doesn't end here. And some towns have insightfully undertaken to change the variance standard to a special permit standard for vertical elevation, but there's still a problem with the height envelope, and so these are challenges that are being met on a very ad hoc basis and need to be perhaps thought of from a policy perspective more uniformly, or I would suggest at least more liberally by municipalities in order to afford protection that property owners are seeking in their waterfront homes.
All right, well, thank you very much, Marjorie. We're going to open it up for questions. We already have a number of questions, and some of them are related to permitting. So I don't think really this is an appropriate forum to to talk about deep permitting questions. But what we will do is take all of those questions, package them up, send them off to Deep, and ask for a response. And we will post both the questions and Deep's response on our website, the Adapt-CT website. So here's another one of our questions. If a structure protects a property, like a seawall, and is causing impacts elsewhere, is the person who owns the structure liable for the damage? There's a couple along those lines. So I'll turn it over to whoever feels comfortable on that one. It's
right.
That one.
Right. So I'll jump in on that one. It seems to me that I did cover that in a slide, which is we can go back to it if we need to, but there are some cases where neighboring landowners have brought flooding claims for trespassing and for creating a private nuisance in cases where they had properly permitted seawalls that caused damage on neighboring properties. And courts have allowed those to go forward even though they did have permits for those seawalls. But those cases do turn on the facts. You have to make all the elements of those claims in order for yourself to prevail. So those are very fact-specific sorts of cases, but it is something that we could see in the future in Connecticut.
Okay, next question. What existing planning and regulatory tools are best suited for dealing with sea level rise, like building codes, floodplain ordinances, zoning regulations, FEMA, the National Flood Insurance Program? I'll let Margie take that one.
The answer is yes. All of them. I mean, the building code is the building code, so it deals with the same sort of FEMA compliance issues that are going to be captured perhaps in your floodplain ordinances or maybe embedded in your zoning ordinances. But let me say this, if it wasn't already implicit or explicit in what I said previously, don't let the concept or the specter of takings inhibit you from exploring what a regulation that matches your science and your physical characteristics. I don't remember how that sentence started, so I'm afraid I can't end it. But don't be inhibited to explore drafting your regulations and implementing regulations. Obviously, consult with town council, but the reality is that the peril to the shoreline and the need to be responsive to what we're confronting outweighs the sort of notion that there's nothing that can be done. There's lots that can be done.
All right, the next question. When does a municipality have the right to abandon infrastructure that has been repeatedly damaged from storms, but that still serve a limited number of town citizens? For example, a road to 4 houses on a point that washes out every few years and it's rebuilt. There's another question that's very similar to that. And can a town discontinue a road because it is subject to flooding during storm events? And also, can a town discontinue water and sewer service to an area subject to flooding?
We don't talk specifically in the fact sheets about discontinuance of roadways. However, I do know that there are some towns in Connecticut, I want to say maybe Guilford or Branford, where that has been an issue. One thing I will say that we do cover is that roadways are considered infrastructure such that hard armoring of those is authorized as a part of the deep, I'm sorry, as part of the Coastal Management Act. A seawall or a bulkhead or something would be authorized to protect infrastructure like that, or indeed to increase its height so it doesn't wash out. That said, I could see situations, and we did cover this actually in another project that we've done in Connecticut in the last year, and if anybody is interested in that, we can provide it. If you get in touch by email, we can send you a copy of it. There are some towns that have discontinuance ordinances along central and southern Connecticut. Very few of them, however, do. That's really the minority. So the acceptance of a town road in most places is sort of the whole situation under the ordinance. That leaves open the question of when and how they can discontinue those roads, or at least public support for them.
All right, let's try this one. I'm not sure there is an answer to this one, but I'm going to read it anyhow. What level of proof or certainty as to future flood threats or sea level rise would be required to sustain more stringent regulatory approaches or sustain site-specific land use decisions? Well, I've got some dead air time here while people are reading the question.
Well, I'd say a high level of proof, but I think that most flood information that we have is historical, but updated. And I think that sustain more stringent. I think that there's latitude for more stringent regulatory approaches, like increasing setbacks. Obviously, anything of that nature is going to come with notice and a hearing, and the evidence that's brought forth by the public in that setting may inform how risky or how appropriate it is. And the reason I talk about science at the outset is, at least in the moment, we still have a administrative discretion to the decision maker on a regulatory basis. There's some action that may alter that because the administrative deference is under some assault elsewhere. But for the moment, the courts are looking at the record. We have record appeals. So this is why the science and the planning and the documentation to be consistent and cross reference to support what the municipality is doing. I think that that is the basis on which a firm decision can be made, but it depends, right, on the circumstances. So this is a general answer to a general question, and the facts will determine how deep that evidence has to go.
All right, the next question. Is there any case law in Connecticut regarding the right to structurally protect land, for example, a backyard, not a house, from flooding and erosion? Property owners tend to believe they have such a right, but it is not supported by the Coastal Management Act policies. Must waterfront property owners accept the loss of land to sea level rise, or do they have the right to obstruct it?
I would say in general, there's I'd say that deep certainly disfavors protection of areas that are not considered one of the four categories of infrastructure or structures that are worthy of protection through hard armoring. So a backyard versus a private residence would be very difficult to get a seawall or a hard armoring permit for that. A living shorelines permit, however, would be potentially a different story. So I think that the question of whether there's a right to it isn't maybe the right word. Can you get a permit for it is perhaps the question, and I think that that question depends on what you'd like to do and how you'd like to protect it. And I know that living shorelines in particular are an area where towns in the state may not see eye to eye in all cases, so it's a really fact-specific question.
I agree with what Reed said. The idea that one might have rights is always tempered by the overarching regulatory scheme, which in your question may have been squarely in the coastal zone. So no, you can't unilaterally do that. You need to obtain a permit and probably a coastal site plan as well.
All right, excuse me. The next one, the California depreciation concept is interesting. As a property value is depreciated, do property taxes fall? And will insurance, National Flood Insurance Program, or private cover the presumably higher market value or the depreciated value? It seems like a mixed incentive for keeping reasonable distance from the shore, though I may be misunderstanding the concept.
I think the answer to that question is to provide a link to the regulation, and I will filter that through Bruce.
Okay. I think we kind of covered this one in the presentation, but does beach nourishment change property lines? Does it make a difference if it's owner or government initiated? Are there tax impacts? Does the assessed value change? And does the calculable building area change?
So this is covered in the Shoreline's boundary, and I'm forgetting the title now, property and permitting boundaries at the shoreline. Beach nourishment is considered a sudden event, an impulsive event, so it does not change property lines, and it does not matter whether the government does it or a private property owner does it. It's still an impulsive event. However, it could change where the CJL is located. It would not change, because it does not change property lines, it would not change any of the, I think, the other list of things in that question.
Right, and it depends on if the evulsive event took the private property, then it would be the private property owner who was nourishing, and then maybe the state would nourish as well. So the private property owner doesn't re-nourish the state land.
Right, yeah, so if there was a storm in this hypothetical, if Sandy came and caused a rapid erosion and a property owner used nourishment to put that property back to its original condition, that person would have that original property back again.
And the building envelope would not change.
All right, what is the downside for a town that restricts development based upon solid sea level rise science, only to later have the courts rule that the restriction is a regulatory taking?
Well, that assumes a lot of facts, not an evidence. and speaks to the notion that the science, you know, courts make mistakes. It's why we have appeals from court decisions. That is a perplexing question, and maybe Reed has an answer to it. Is it a foregone conclusion that the court won't get it wrong, meaning no disrespect to the courts? No, but that's what appeals are for.
Right. And in the worst case scenario where there's been a taking, where the court finds that there has been a taking, the downside is that you have to pay money as a town. Right. That's the downside, the worst case scenario.
Yeah.
Right. So
maybe. I want to say with some emphasis that we have very vibrant regulatory schemes and laws in the state of Connecticut that have withstood judicial review, which is not to say that there's not an instance where somebody will go too far or has gone too far, but which is to say, I guess now for my third time, please don't be intimidated by the notion of takings.
Can a value be placed on public trust lands if an individual is the sole beneficiary when sand shift? Loss of sand in Madison or some other place that has shifted from public benefit to private benefit.
I'll give that a shot. And that is to say that the movement of sand is a natural phenomenon. Sand goes from property to property, and you can't say, hey, that's my sand once it's moved on, right? So movement from public trust lands to private waterfront areas by accretion wouldn't necessarily result in a change in the public trust value, or indeed a change to the public trust at all. The public trust is still the public trust, even if behind a seawall all of the sand is goes below and the beach is totally lost. That those lands are still there. So it's a sort of a tricky question to answer, but that's my best shot at it.
All right, well, that's the last question we have. I'd like to thank Marjorie, Reed, and Audrey for participating here. And the questions and fact sheets, as I mentioned before, are all up on the Adapct-CT website, which is at climate.uconn.edu. Thank you for all participating, and again, if you have any questions that you would like to have answered that you didn't think of at this point, you can reach us at the Adapct-CT website.